this handwritten will revoked everything they did. Hi, Jeff Mersace, the Plain English Attorney, and welcome to today's video where we're talking about how you shouldn't Frankenstein your trust. Okay, this is a good one for Halloween, using the Frankenstein's monster of a trust, and it's because I reviewed a couple of these in my time as an attorney, and sometimes it just all ends up being together in one place. What I mean by Frankensteining a trust is trying to change and amend and update a trust without using the correct proper format. Now, when you have a revocable living trust, there are two things. You've got your state rules, but then you also have the document rules. And state rules say that, okay, a trust just needs to be in writing, signed by the person who's setting up the trust, and that's it. That's North Carolina. So you can create a trust, a written trust, with just that. You don't need witnesses, you don't need notaries. But you know what? That becomes so easy to argue that you inadvertently ended up amending that trust by writing down some notes. Oh, I got a Post-it note and scribbled something down. I was like, oh, well, okay. So if you've got a good trust, and it was done and put together by attorneys, it's going to state that there is a process for amending the trust that makes sense in the way we do it to make sure that you actually mean it to be an amendment, is that it has to be in writing, signed by you as the person who set up the trust, witnessed by two people, and notarized, which is the same formalities that we use when we're executing a revocable living trust. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So you can't just go and do things like, oh, I'm going to cross it out, I'm going to take some pages out and put some new pages in that are redone, and oh, I'm going to have a handwritten amendment, just slide it in at a certain point. No. You can't do that. You have to be serious enough about your trust and amending it that it's done the right way. So here are 4 ways that we've seen trusts end up being attempted to be amended, but really just kind of ended up being a disaster. Okay, first way that I've seen this, it's simply crossing out a name and writing one in. And, oh, well, I'm just going to initial it. Wait a minute. That initialing can be done in a legal document if it's done at the time of signing. So let's just say you put together that revocable living trust and, oh, wait, here's a spelling error. Rather than printing the whole thing out again, we're going to cross it, we're going to initial it, and then you're going to sign it, and it's going to be witnessed. So the witnesses saw that you updated and changed that thing and put a little initial next to it. So it was executed with the same formalities. It's just, all right, the printed document had a little bit of a notation before you signed it. Going back days, months, years later and crossing it out and initialing it, they didn't witness it and it wasn't notarized, so it's not valid. And different state rules will have different effects on what actually happened. The most common one I see is if a daughter got married and, oh, that's not her name anymore. I'm looking through my documents. I'm just going to cross it out and write the new one. Don't do it. Don't do it. One time we saw that the daughter got married, took her husband's last name. Okay. They crossed it out, put her new name in, initialed it. Daughter got divorced a few years later. Crossed that out. Wrote back in the name that she used, which was going back to her maiden name. Got married again, crossed it out, put in the new name, and then, oh, what? Wait, she got divorced a few years later, crossed it out. So 10 years later, they're coming back to us. Their daughter had been married and divorced twice, and there's this scrunched up scrawl of crossouts and initials, and it's no. That's going to blow up your trust. All right, do we have a second way? Oh, yes, we do. We have a second way that this was kind of turned into a Frankenstein's monster. changing your mind on people. And this is more so, well, it's in the trust as the trustee, but it can also be a power of attorney or the executor, or even percentages of inheritance. I saw this, some clients many years back. I didn't set up the original document, but they came to me because the attorney had retired and taken off and they didn't know where he was. So they contacted me. They sent me a couple of pages of the trust. Hand to God, here's exactly what happened. They had crossed out a name because the person fell out of favor. So that, okay, there's the list of inherited people and that got reduced by one. But then they changed their mind again and in something later in that paragraph. And so they put an arrow with another name and then initialed it. And then even later, they had other crossouts and changed some percentages and wrote all of this in. And when they sent it in to me, their question was, what did we mean? How am I going to know what you meant? Don't do that. Do not write on your original documents. That's a big, huge thing. Don't ever do that. You do that, you're only going to cause a bunch of problems that you really don't need. And it may not even be you who's handling it. It could be your trustee trying to figure all this out. And where's it going to get figured out? At least some formal proceeding, probably arbitration, or maybe even having it end up being contested in court because you went and messed around with the originals. Don't ever write on those originals. All right, third way we can quote Frankenstein and cut up and put together a trust. And I've actually seen this. This really is kind of like replacement surgery on a body that's sort of living, but then it ends up killing them. Like, okay, we're just going to take this arm off and put another arm on. They'll undo the staples. This was a law school case. Undo the staples, take out a page. Put a new typed up page in that had the changes and then just staple it. Okay, again, this is the Frankenstein's monster. You can't just slip a page in because it wasn't in writing, signed, witnessed by two people, and notarized. You're just replacing a page. And the question, the thing that was in a law school case, how do we know that you were the one who did that? Maybe it was someone else. Especially if what you did was you cut out or lowered a beneficiary's percentage and put in or raised another beneficiary's percentage, and that page just gets slid right into the trust and then restapled. How do we know it wasn't the person who was getting more? And now it becomes a court case. So this is how we typically handle this whenever we're doing, we call it a complete amendment and restatement of a trust for our clients. So even if there's really a minor change, even most of the time, okay, we're just going to put in that change and we're going to note at the beginning and prior to the signing that this is an amendment and restatement of the old document. It's still the same trust. It still has the same name. It still has the date of formation from when you originally set it up. But even though we're just making one change, we're just going to print the rest of the document out and sign it. Now, there are a couple of reasons why this is actually a good thing once you're gone. And it relates back to another story. A financial advisor that I do some work with, he sent someone over to me and he was like, okay, the gentleman who passed on wasn't one of my clients, and the gentleman who came in was the son and the trustee, and he wasn't one of my clients at that point. And he's like, okay, look, I need help settling my father's trust. Here's the trust. I already knew there might have been a couple of problems because it was even less than 20 pages in there or so. And here's the first amendment to the trust, and it was like 3-4 pages. And here's the third amendment to the trust, and it was 2 pages. And I'm like, well, wait a minute, where's the second amendment to the trust? Oh, I don't know. Okay. That second amendment to the trust could have changed a whole bunch of beneficiaries, changed who the trustees were, given a whole bunch of money to someone else or a charity. We don't know. So how can I help settle this trust if we don't have the complete thing? So it was several weeks later when he really started digging through a whole bunch of papers. Where did he find that Second Amendment to the trust? At the bottom of a desk drawer, stuck to the bottom of a stock prospectus. Why? Because one of these oversized coffee mugs apparently went down right on top of that Second Amendment to the trust, spilled over because there was a big coffee ring around it. And when he took the coffee mug off, that's how it got stuck to the stock prospectus, and it just got shoved in the bottom of a desk drawer. All right. The trust that we do, anywhere from 70 to 120 or more pages, it's a thick document. So even if you're making that small change, we're updating the whole document. The other thing was, even though he had the Second Amendment, here's how I had to review the trust. I had to lay it all out. Okay, here's the trust. Read through it. Go through the Second Amendment to the trust. Okay, here's what was changed, because it would only change those little points. It didn't print it out again. Okay, so here's these points. Okay, note here, go back to the trust. Okay, here's the Third Amendment to the trust. Oh, this changed something in that First Amendment to the trust, and it also changed the trust, and then went to the Third Amendment. It became about 4 more hours of having to review the trust at my hourly rate just to get it straight what the trust meant. If all I have to do, and if all any attorney has to do, is just read that one document front to back, then it's a lot less time trying to settle the trust, because the attorney then knows exactly what it is without having to flip through and go through multiple small amendments. So, okay, this section's changed and it's going to say this instead. And okay, go back and wait a minute, this other thing gets you. No, it's easier to just do a complete amendment and restatement. Just print the document out. It's not like we're back in the days where each attorney had like 3 or 4 secretaries drafting stuff and typing it up, and we didn't have word processors. No, we've got word processing software. You save the document, you make the change, you print it out. That's it. Fourth way that I've seen this, and this could and has ended up completely blowing up an estate plan, it's trying to do a handwritten amendment. So we actually had some clients that we worked with, and they did this on their own because, well, we don't want to pay, I think it was estimated something like just a couple of $100, not a huge amount. I mean, literally somewhere around $200. They didn't want to pay it. So what they did was they took some form document and they wrote out a lot of the stuff that you'd normally see in a last will and testament. And what they did, now let me lay out the situation a little bit more. They had one grandson that was going to be the beneficiary. They had several kids, but it was the one grandson who was a special needs beneficiary, and they wanted to just change one thing in their overall plan. So revocable trust, special needs trust, all these other documents. So they did this little handwritten thing, and they used the language that I hereby revoke all previous estate planning documents. So they destroyed, in this handwritten holographic will, that's what it's called, this handwritten will revoked everything they did. And the only thing that they did was change that one thing that went to the grandson. So now they had no estate plan other than that. Everything should be going to the kids rather than the grandson, and that's it. Plan blew up. Nothing we could do because the person who wrote it out had passed on. So we actually did a video on that called The Anatomy of a Destroyed Estate Plan. We'll go ahead and put a link to that in the description. But that's another way of Frankensteining your trust, is just by putting together some kind of handwritten amendment. Now, I've recently seen a document that did a whole bunch of all of these. They had crossed out when names changed. They changed percentages with handwriting. They had slipped in retyped pages that had different language. And I even saw slipped in a handwritten amendment just explaining what they wanted to change and then signed it. but it wasn't witnessed and it wasn't notarized. None of it was witnessed and notarized. And it really did look like this hodgepodge of pages that were thrown together with a good percentage of the original trust, but just enough of these other things that really, if they passed on, this is going to blow up. So thankfully, we found it in time that we can go ahead and actually get a complete amendment and restatement and get everything on track. Now, look, this is some good information, more as a warning, a very scary warning around Halloween time. Don't Frankenstein your trust. But if the only thing you remember out of this is please, please, please don't give your attorney a heart attack. Don't make their blood pressure go up. Just don't write on your original documents. It's only going to end up blowing things up. So I hope you learned a lot from that. I hope you got some good and useful information out of it. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.